All right, and so this is Katrina James.
Yes, it is, Your Honor.
All right, we are going on the record in the matter of the City of Wyandotte versus Katrina James, 231417. And appearance counsel.
Your Honor, good morning, Richard C. Serrano, P33828. I appear as MSG counsel today on behalf and with my client is presently in custody for arraignment. Please state your name, ma'am.
I'm sorry.
Can you please state your name?
Oh, Katrina Rose J. You're a little distorted from the echo.
Okay. All right. And counsel, as to the arraignment.
Your Honor, I advise my client of her constitutional right to carry with her throughout this case. Also, the nature of the charges against her, the maximum penalty for default. I believe she understands both. We thereby we wait for her reading standing.
The court will waive the formal reading, enter plea of not guilty for purposes of the record of the arraignment, and we will schedule this matter for pretrial June 27th at 9:15 a.m. Ask the bond counsel.
Your Honor, my client tells me that if she were released, she would go back to the house in Wyandotte. She's originally from Pennsylvania, and Your Honor, she tells me she's divorced. She supports one minor child, daughter, age 16, who is in Pennsylvania. She promises to appear in court, Your Honor. She's going to remain in court for this matter, remain in the state until this matter is concluded. She tells me she does not believe she has any other criminal matters pending and is not on probation or parole. So we ask the court to consider a personal bond, or bond she reasonably expects to post. She does have, if needed, $150 to pay towards a bond.
Okay. So, Ms. James, how long have you been in the state of Michigan?
I just relocated semi-permanently in December, and I travel back to Pennsylvania every 2 weeks to see my daughter until she's ready to come out here. She's finishing school this semester.
Okay, so ma'am, what brought you to Michigan?
Love.
What?
I came out to be with somebody.
Oh, you said love, okay. And so you came here in December, your daughter didn't move with you. And when are you thinking that your daughter, please let me finish. When is it that you think your daughter was going to be coming up this way?
Pardon?
When is it you think your daughter was coming up this way?
Well, me and my partner were in the process of closing on a house. So probably July, we signed the paperwork Wednesday. She has, what, 20, 30 days, so it would be July. What's Wednesday? Oh wait, today's the 13th, so it'd be July 14th that she would make it, 1 month after closing. So July 14th is when she'll be here.
And so how long have you known this person you relocated to Michigan for?
25 years.
About a year?
25 years.
25 years, okay. Did your partner live in Pennsylvania previously?
No. It's been a long distance relationship for a long time. It's just a lot to orchestrate, making a move that big with a kid in school and securing a house and work and everything. You gotta, everything in phases.
Right. Right, so, why didn't you just wait until after your daughter had graduated high school before you made the move?
A lot of it is she's actually getting ready, to graduate. She wants to go to the independent studies program out here in better schools. That's why I'm making the jump too. It's better schools out here, better education. I don't want her to get less than what she needs to survive. Just trying to create a good opportunity for my kid, ma'am.
Well, man, based on the allegations, I don't think that you're creating much of a,
I'm
much of an
aware.
example for your child. Who is your child living with right now?
She is currently staying with her father. We have 50-50 custody. When I go back to Pennsylvania, I go back every 2 weeks, and I'm there for 2 weeks. So I'm 2 weeks in Pennsylvania, 2 weeks here, 2 weeks in Pennsylvania, 2 weeks here. Back and forth a lot.
Well, again, that doesn't answer the question as to why you didn't just wait until your daughter was done with school for the year before you moved up this way.
So she is done with the school year. I needed to come out to get things set up, start looking for a house. So that way, when she finished the school year, we've got the house and everything ready so we can make the jump during the summer instead of during the beginning of the school year. We wanted to wait until she was out of school for the year to make the jump,
Okay,
not interrupt the school year.
I understand that, but then you also said that she was set to graduate this year.
Yes. She is. So she's done. Now she's going to be going to the college out here.
So she graduated high school at 16 years old?
Yes, ma'am. She tested out. I'm very proud of her. Very,
So
very
what
proud.
college is she attending? What college is she attending out here?
She's looking at MSU. Is where she wants to go, is MSU.
So is she applied and been accepted to Michigan State already?
Yes, she is applied and she is accepted. I'm just trying to pave the way for her, and I messed up now.
I'm not sure why you found it necessary to come buy a house down this way when she's going to be an hour and a half away.
My
So your
partner,
reasons don't really make a lot of sense.
my partner works at Brownstown, or for the Ford plant, yeah, at Brownstown. So that's kind of why we picked towards this way, was because it's close to his work, it's closer to where I'm going to be working in the city of Detroit, like I do a lot of stagehand work there. And so it's easier for us to work and be able to support her at school when we don't have to commute very far.
Okay. Here's what the court's going to do. Given that, you've been here for a few short months, are you on probation or parole anywhere in the state of Pennsylvania?
Not that I know of, ma'am.
It looks like she, one time she had an operating while intoxicated, Your Honor, but she tells me she successfully completed that case.
Well, it seems as though your client either has a continuing issue with alcohol or she relapsed.
I relapsed, ma'am. Yesterday, I hadn't touched alcohol since my DUI, and then last night, I definitely had a relapse.
She also told me that if tested, Your Honor, she would test positive for marijuana. She's recreational marijuana. She has no medical marijuana card.
The court's going to indicate $7,500, 10% bond. In the event you post bond, you are not to be released on alcohol covered through the Wayne County Jail.
Pardon?
GPS and alcohol covered through the Wayne County Jail. You're also not to leave the state without, you're also not to leave the state, ma'am. So you have to figure out some other way to see your child. As a possess consuming alcohol or drugs unless prescribed. Thank you.
Thank you, Your Honor.
Off the record. You have a good day.
Welcome everybody, how we doing? Happy Monday, happy Juneteenth. Is it happy, merry? I don't know what it is, but it's Juneteenth. Welcome to Time Served. I'm your boy Phil, and had to get my girlfriend in. Going through withdrawals today. Need her in my life daily. I love you. Okay, alright. I see the regulars tricking in. Darkova, thank you for the memberships. I hope you guys grab it. What's up, Trevor? How we do? Horror fan. Grim with the great comment, Dr. Robotnik. I love it. Charles, hope you're feeling good. My mods are in the room. If you need anything, please let me know. Let's get it going. I have stuff from the vault. Guaranteed you never saw the one that I'm going to play later. But maybe you saw this one. How good was that Judge Washington find today? We had close to 1,000 people in the chat today. That was unbelievable. Looks like we're going to be doing some premieres more. And I think not having court helped that too. But I digress. Let's get it going with a little. Let's see. We're going to go to Judge Washington. Let's roll.
State of Michigan versus Tarika Jackson, case number 18S00335.
Rachel McDuffie for the people.
We love
Assistant
Rachel
Public
McDuffie.
Defender Shanazi Carey, I can really, on behalf of Tarika Jackson, Your Honor. Tarika Jackson, can you unmute and state your name for the record, please?
Oh, wait, hold up. This isn't the one. We're going this one. Sorry, guys.
Are we ready on the McGowan?
Played
matter
that one
yet?
already. Here we go. So we're paying attention. All right, so I'll preface this one. Mr. Felbert Claiborne on the bottom was not supposed to be in court the day before. So he signed in, logged in, caused mass confusion in Judge Washington's court, and now he's here on his actual date, looking very confused yet again.
Okay. The court will call the case of the State of Michigan versus Stelbert Claiborne, case number 20S00194.
Rachel McDuffie for the people.
Assistant Public Defender Shanazi Carey, I can really, on behalf of Mr. Claiborne. Mr. Claiborne, can you state your name for the record, please?
You're muted, Mr. Claiborne. Please unmute your device.
I'm sorry, Shelby Claiborne.
Thank you, sir. Thank you, sir.
Your Honor, we are asking for an adjournment in Mr. Claiborne's case. I don't think that Mr. Claiborne, this is only the one, so we would just be asking for an adjournment on the two. He's hopeful that he would be able to get his license within a month. We understand that Mr. Claiborne, you can unmute and say.
Well, from what I found out, all I can do is just pay this money off because I'm not going to be able to try to get my license until November next year, according to Secretary of State.
Okay. All right. So you're going to take the no operator's license on person in the civil infraction?
pay whatever money I owe the court.
I didn't hear you, Mr. Claiborne.
I said, I'm gonna just have to take I'm gonna have to I guess, take what you just said and just pay whatever money I owe. I can't apply for my license till next year.
Okay.
All right, Mr. Claiborne, the offer is for you to plead to no operator's license on person that is a misdemeanor, carries a maximum penalty of 90 days and or up to $100 fine plus court costs. Do you understand that, sir?
Yes, ma'am.
That is the offer, correct, Ms. McDuffie?
And the civil infraction for the insurance.
So you'd be pleading to an added count 3 of the no operator's license on person, and they would also offer a civil infraction of operating without, of no proof of insurance. So it'd be 2 charges. Do you understand that part?
What is he, on the freeway? Yeah.
I'm just writing it up.
I have one question, Your Honor.
Yes.
How much more is this gonna add to what I already owe, and how long do I have to pay it off? Because I know
It'll add quite a bit. There's no operator's license on person. There's a fine of
No, I see. Terry, that is not her audio. That's Mr. Claiborne's audio. As soon as he's off, it's gone. I really think he lives close to a freeway and he's got like the door or the window open and it's his audio. Just him.
$325. And then the no proof of insurance is $155.
And Your Honor, Mr. Claiborne should also know that he has a DWLS warrant out of 14A2 as well. He has not yet been arraigned on. I think it's been a bench warrant status since 2021. So he might want to be aware of that too.
All right, sir, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may lower your hand. Sir, I'm gonna go over some rights that you have that you're gonna be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney, okay?
Yes, ma'am.
You have the right to have a trial by a jury, at which time 6 people will decide whether you committed this offense. You can call witnesses at that trial. You can get an order signed by me to require that they come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. And you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights, sir?
Yes, ma'am.
Do you understand you're going to be giving up all those rights? You're not going to have a trial of any sort?
Yes, I do.
And do you also understand there's no automatic right to appeal this decision, sir?
Yes.
So therefore, this is likely to stick with you. In addition to that, sir, if you're on probation, parole, or bond at the time, this could be a violation of that. Were you on any of those?
No, no.
And in addition to that, if you're not a U.S. citizen, you've got immigration consequences. Are you a U.S. citizen?
Yes, I am.
All right. And then to the charge of driving while no operator's license on person, how do you plead?
Yes.
Does anyone promise you anything other than what we placed on the record today to get you to plead guilty, sir?
No, ma'am.
All right. Anyone threatening you in any way?
No.
All right. On November the 24th, 2019, were you operating a motor vehicle in the vicinity of South Harris and Davis Street in Ypsilanti Township, sir?
Yes, ma'am.
And at the time, did you not have a valid operator's license on your person?
I didn't.
All right. Then the other, and do you accept responsibility for not having proof of insurance on that same date?
Yes, ma'am.
All right. Thank you. Anything further? Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Defense is satisfied as well.
All right. Anything from anybody prior to sentencing?
Nothing at this time, Judge.
All right. Thank you. Anything you want to say, sir?
No, ma'am. I'm just ready to get this over with.
$325 fines and costs for the no ops, and then $155 for the no proof of insurance. And are you on a payment plan right now, Mr. Claiborne?
No, I'm not, but I want to get that started. What do I
Freeze.
owe? Don't
Office teller, payment plan per month.
What's up, monkey?
And can you pay that on the 15th of each month?
I get paid every 2 weeks, so that's what I'm trying to get this over with fast.
Can you pay that on the 15th of each month, Mr. Claiborne? You can pay as much as you want, but that's the minimum. Okay. $100 on the 15th of each month. I'll see you back here on September 21st, 2023 at 10 a.m. If I'm paying at least that amount, then you don't have to be here. If you're not paying that, then you have to show up. If you're all paid off, that would be great. Okay, Mr. Claiborne?
All right, thank you.
Thank you. All
Right.
the
Good job,
accounts are
Claiborne.
dismissed.
All right, now we're gonna go. This is an oldie, not too old, couple weeks. I had it in the vault. Kirkman. We'll love a little Kirkman. Just listen to this. This is gonna. Don't like it at all. Here we go.
Michael Bombella versus Jasmine Miller. Today is Monday, May 15th, 2023 at 10:32 a.m.
Court would note the appearance of Ms. Huffman on behalf of the plaintiff, Ms. Pasno on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Huffman.
Thank you, Your Honor. I'll just address real quickly. So in this case, either there is an established custodial environment with both parties, as both parties cared equally for the children their whole lives from birth up until the parties separated in mid-January. This action was filed in April, mid-April, or I think beginning of April, actually April 9th, I believe. But as a temporary solution, so if there isn't a
Rated memberships. Thank you, monkey. Grab them.
Custodial environment, established custodial environment, then obviously there would be no custodial environment at all. We don't believe there is an established custodial environment with just mom because there hasn't been enough time established. But in any event, as a temporary solution, we'd ask the court to start standard parenting time every other weekend to start immediately, either this weekend or next weekend, with dad. I don't think anything has been alleged or to make this court believe that Mr. Bombella is incapable of caring for his children, or that it wouldn't be in the children's best interest to be with their father at least that limited amount of time. So we'd ask the court for parenting time at least that amount, and we'd also ask for half of the summer to start sometime in June. So if we want to start with some every other weekends for a month, and then start in June, mid-June or whatever, for half of the summer, week on, week off, I think that would be a good idea. And then by the time we set or have our hearing or mediation, I think we could probably get this resolved by then. Thank you, Your Honor.
And thank you. Ms. Pasno?
No, thank you, Your Honor. My client does believe it's in the best interest of these minor children for father to have supervised parenting time, as alleged in my answer. Dad works at Post, where he works third shift. He was working 12-hour shifts and has been for a period of time, where he has to request time off, including requesting time off for each weekend he would ask to have these children. And he's often forced to work a lot of overtime. When he took this position, he was very confident with my client that he'd be making a lot of money due to the fact of how much he would be working. In regards to the parenting time every other weekend, my client is objecting to that. She would prefer supervised parenting time with no overnights. We are told that he is living with Nicole Bibbins, who is his girlfriend, who has a history of drugs, drunk driving, light driving while license suspended, and often evictions in the Calhoun County courts. And I believe this court could take judicial notice of those charges. The plaintiff in this matter also has a history of taking ecstasy, as well as bragging to my client that he wanted to start selling marijuana again, which raises major concerns for my client for these minor children who are only 3 to have unsupervised parents.
Nothing better to get your kids back than bragging to your wife that you take hits of ecstasy, and deciding to sell pot again. Great job, dude. Way to go.
Time with their father.
Allegedly.
My client has been solely responsible for doctor's appointments, day-to-day routines, bedtime routines. The plaintiff in this matter has not seen the children since February 6th of this year, and he has not reached out, besides through attorneys on 2 occasions, to see the minor children during that period of time. My client was aware he had time off, and he didn't request parenting time during those periods of time as well. My client also has concerns in regards to him working 3rd shift, being able to be awake during the day for these toddlers. He has a history of leaving his guns and knives out, which my client always had to clean up after him. In addition to that, these minor children are currently being tested for autism. They're going through evaluations. Dr. Ismail has recommended that the children stay in a consistent environment with their mother during this testing to make sure they can determine if there's true autism or not. So we're asking that this court enter an order for alternate weekends, Saturdays from 12 to 4, Sundays from 12 to 4, being supervised by a mutual agree upon supervisor, which would exclude his current girlfriend, and ask that this court enter an order regarding the same. Also, in regards to child support, it's believed that dad's earning approximately $90,000 a year. My client works for Verizon, where she works from home, and she makes $65,000 a year, and ask that child support be calculated using those figures as well.
Okay, thank you. Anything else, Ms. Huffman?
I would just state that my client is living alone in a 2-bedroom, 1-bath apartment. He lives on Michigan Avenue East. I have the address here, but he does live alone. As I stated, it's an appropriate 2-bedroom, 1-bath home. He stated to me that he is able to get every weekend off. He can stay awake. There's no issue with that. He's an adult. I don't understand why there would be a problem with him being able to stay awake during the day. Consistency with these children is going to include dad, period. That dad is going to be in these children's lives. That's just the end of the story. So consistency, the sooner we get that started, the better it'll be for the children, and I think that needs to start immediately. And we're fine with child support being whatever the numbers are. So if mom wants to, if Ms. Paisner wants to send over numbers, we can get that going. Whatever child support calculates to, we're fine with that.
Okay,
thank you, Your Honor.
Okay, what the court's going to do in this matter, the court will grant temporary custody to the defendant mother, support pursuant to the guidelines. So court will order that the parties would.
I see somebody talk about Tan Mom. I live in the same town as Tan Mom. Well, she moved to Florida, but literally about 5 blocks away. She's from my town. Yes, swear.
Exchange their income information within 7 days of today's date, and the court would grant to the plaintiff standard alternating weekend parenting time, 1/2 the summer, and alternating holidays. The court will grant first holiday being the 4th of, be Memorial Day. Memorial Day, the court will grant Memorial Day to the plaintiff, and then alternate holidays thereafter. And court will order Ms. Huffman that you would prepare that order and submit it under 7-day notice of entry.
Thank you, Your Honor.
Your Honor, is this court going to comment about who the minor children will be left with, or does he have to be present during his parents' time that he's acknowledging that he can take those weekends off?
I'm not going to address that, Ms. Paisner.
All right, thank you, Your Honor.
Okay, thank you. Court will end this matter at 10:30.
And Tan Mom was exactly how she was on Howard Stern. That's exactly how she is in real life. Like, you see her in like ShopRite, bagel store, and she is exactly how you see her on Stern. I swear. And the husband, the kids, it is a fiasco. When that thing happened to her, when she was in the news, why she was on Stern, oh my God. It was crazy here. Absolutely crazy. All right. Chief Justice McConaughey up next, And then I have a case from my home state. Let's go with Mechanico.
That Mr. Gray is accused of shooting at people.
Ooh,
And
there we
that
go.
the complaining witness stated that Mr. Gray had come to the scene with Miss Smith and had shot at him and then
Yes,
tossed
Lynn.
the gun
Met
into the
her.
grass, and that the police recovered both the gun and 3 spent shell casings. So we do think there's a danger here to the public. This is alleged to have happened outside. That when the police got there, there was a crowd. I'm not sure when they're supposed to have shown up, but Your Honor, we do believe that there's a risk to the public here.
Bond continue. If he makes bond, add the GPS tether with a 10 p.m. to 6 a.m. curfew. Thank you.
Judge.
Good luck, sir.
We have
Oh boy.
Jason Miller.
Next.
Who's Jason Miller? Are you Jason Miller? You got to get a deputy to unmute yourself up there, sir, on the
Oh boy.
floor 6.
There he is.
Madam Clerk, can you unmute him over there?
My name is Jewel Boyd. I use that as an alias, Jason Miller.
Okay, I hear you. All right.
Calling case
He has an alias. I love it. Guys, in the chat, what's your alias?
220-571-2401, people of the state of Michigan versus Jason Miller. Defendant is charged with count 1 retail fraud, first degree. Actually, the defendant is labeled as an habitual offender for offense notice. Also calling case 220-584-8401. People of the state of Michigan versus Jason Miller. Defendant is charged with count 1 retail fraud, first degree. Second or subsequent offense notice. Defendant is labeled as a habitual offender for offense notice. Today's the date time for a bond redetermination hearing.
Jennifer Douglas for the people.
Break it on behalf of Joe Boyd, also known as Jason Miller, Your Honor.
What are his 2 bonds?
5,000 cash, capious bond, 5,000 cash, capious bond.
Okay. Argument.
Judge, these are retail fraud matters from Meyer. They're non-assaultive cases. Mr. Miller doesn't have any assaultive. He's on probation for retail fraud, Judge. So, you know, this is what we're talking about. He also received Social Security disability. He was in inpatient treatment at Share Macomb, Your Honor, somewhere where he was ordered to go back to. Mr. Miller, you did 90 to 120 days in the Share House treatment program?
Yes, I do. Yes, I did. I am a member of mental health court, and they sent me, and I completed successfully Share Macomb, and they sent me to Abundant Recovery, and I wasn't aware that it was another program, or I would have had to agree to it. I was looking for transitional hours.
Gotcha.
So,
Gotcha.
so the judge sentenced me because I left. I did not cut the tether off. I did not commit a new crime. I just left the program. So when they found me with my tether on me, they brought me back to the jail. She sends me to Sheriff Macomb.
I got you, brother boy.
Okay.
That's where we are, Judge. That's where we are right now with Mr. Boyd.
Attorney Phil Reagan just called him brother boy. All right, brother boy. I can't. I absolutely can't sometimes.
You know,
brother
he's in a
boy.
mental health program, and
That's my
you know, we have retail
brother
fraud
boy.
matters before the court. So my asking for I'm asking for a personal bond, Judge. You know, I want him to be able to resolve these matters. They're from 2022, you know, April and July. So whatever the court sees fit, we just want the court to have all that information when the court makes a decision on bond. Judge Sabri case now. The case is going back to Judge Sabri, Your Honor, because these are retail fraud first degree matters. These are felony matters.
Okay, Madam, name's Ms. Douglas.
Your Honor, the people, like Mr. Reagan said, these are retail fraud cases. Although they're felonies, they are non-assaultive. Our only concern is that there are multiple failures to appear. On the one case, there was 2 failures to appear for PCC. We don't have an objection to a reduction, but would like the court to consider a tether or perhaps a higher personal bond.
5,000 personal bond on both, GPS tether, 10 p.m. to 6 a.m. curfew, and a no contact with any Meyer. You understand, sir?
Yes, yes, sir.
Okay, thank you.
Can I say something, Judge?
Well, I wouldn't, because this is not the trial yet, brother Boyd. We're just getting your bond. We want to make sure you get out, get your person, get your tether, and then we can talk about it later.
Okay.
Thank you so much, Mr. Boyd. Thank you so much. Good luck to you.
Good luck.
All right, thank you.
You're welcome.
Fantastic, brother boy. My alias. I love it. All right. Got one from Jersey. All right. So this one made headlines, local news. It was I would think these were Karens. I'm following it. Hopefully we get more. I'm trying to find some stuff in my local news footage, but I haven't found any yet. I did see this because it was kind of local, but it was intense. Karen fight. Let's do.
Who do we have in the mobile court? Case number 1, you. Yes.
Then has seemingly read.
And this blood. This is Superior Court of New Jersey Criminal Division Judgment.
Blood coming down from above the right side. Supplemental
Superior Court of New Jersey Criminal Division Judgment.
Has there been any discussions among
here we
counsel
go.
that I should be made aware of?
Let's do it.
No, Your Honor. I have reviewed the following documents. I have the complaint with the affidavit of probable cause. I have the Rawway Police Department incident report and supplemental investigation report. I have a picture of the victim's head, showing the blood coming down from above the right side of her face.
Yep.
I have the PSA. The PSA gives the defendant a 3-on-6 as a risk to not appear, a 4-on-6 of a risk for new criminal activity. I have the notice of motion for pretrial detention. I have the defendant's criminal history records. Those are the documents I have. Is the state relying upon any other documents that I failed to identify? Oh, I'm sorry. I also was sent a video link, which was a surveillance video. Again, looked like a Ring video, which shows the assault in progress. Are there any other documents or any other pieces of evidence the state will be relying upon today that I failed to identify? No, Your Honor. Those are all the documents. And Ms. Waters, do you have the discovery that you need to proceed today?
Yes, I do.
And what is your position regarding probable cause?
I'm stipulating to probable cause for the purposes of today's hearing.
Thank you. Mr. Sanchez, I've reviewed the documents I identified. I watched the surveillance video. Whenever you're ready, sir.
Thank you, Your Honor. The state is seeking that the court grant its motion to detain this defendant pending the disposition of these charges. The state asks that you find the defendant a risk of flight as well as a danger to the community. And notably, obviously, her history is old. The state will be relying in brief on the history and characteristics factor under the Criminal Justice Reform Act insofar as it relates to pretrial detention motions, and noting that the defendant's history is old, but here, and Your Honor, hopefully could see that the defendant has seemingly resurrected that pattern of criminality. She does have the 7 prior indictable convictions, as well as the 10 disorderly persons convictions, as well as 2 violations of probation, and of course, the 17 failures to appear. Regarding the nature and circumstances of the offense, the surveillance captures a pretty horrific assault from the state's perspective. And the state is cognizant of the fact that maybe perhaps arguments could be made about perhaps the victim who was briefly before the assault began on top of one of the defendants or assailants, rather. But that doesn't mistake, and that shouldn't dissuade the court from finding the defendant a danger, because she went across the street to grab what is alleged to be a metal pipe, and then return back across the street. And that's what the surveillance video shows, and then strike the victim and strike her rather bluntly. And of course, the victim had injuries that the court can glean from both the affidavit of probable cause, as well as the second page of preliminary law enforcement incident report. And so from the state's perspective, the weight of the evidence is strong. Any arguments that could be made about the perception of the video and perhaps injuries to one of the assailants caused by the victim, the state wasn't able to detect that from the actual video. Obviously, if there was a stipulation of probable cause, then there's a concession that the defendant, there was a well-grounded suspicion that the defendant caused, in fact, these injuries. Obviously, the pretrial services recommends no release, and that's exactly what the state is citing in favor of detention. And so for all those reasons, Your Honor, the state asks that this defendant be found a danger and that no real release conditions could possibly contain the danger that she poses to the community. And with that, the state rests, Your Honor.
Thank you, Ms. Waters.
Your Honor, I am asking that the court release Ms. Hicks today on appropriate levels of conditioning. And I want to start, the facts of this case are quite convoluted here. But I want to start first by speaking about Ms. Hicks. Ms. Hicks' PSA score here and recommendation is based on information that is extremely dated. Ms. Hicks now stands before the court. She's a 53-year-old woman, and she does have a criminal record. But if you look
53. That is a haggard 53.
at the dates and the nature of those offenses, we're looking at offenses that date back to the 90s to 2004, and then most recently an arrest in 2007, and that is the only offense involving violence, and it was for a third degree. So I would note that Ms. Hicks does have a criminal record. There's no question about that, and that's where our scores and recommendation come from. But for the last 16 years, Ms. Hicks has not had any interactions or criminal activity with the legal system. And when I asked Ms. Hicks and looked into what she's been doing for the last 16 years, what she's been doing is getting her life together. Ms. Hicks is a woman who has struggled with chronic depression and bipolar disorder. In the last 16 years, she relocated out of an environment that was very bad for her in Newark. She lives in Woodbridge in her own apartment. She receives disability, and she is undergoing psychiatric treatment.
Okay, so just give you a little geography here. She moved to Woodbridge from Newark. If anyone knows anything, Newark is very bad. Comparable in Michigan to Detroit. Very dangerous. So she was probably running shit in Newark. Went to Woodbridge, a lot better. So running amok in Woodbridge.
She goes every month to see her doctor at University Hospital. She takes medication daily. She brought that paperwork with her when she turned herself in upon learning of this warrant so that she could maintain her medication plan even if she went to jail, which she did. Ms. Hicks is a woman who, for the first significant chunk of her life, clearly did not have her mental health condition under control, and that resulted in problems not only for her, but for the community. And then that changed. So I would ask that Your Honor take into account, when you look at the PSA score and the recommendation, the dates, how long it's been, and the consistent pattern of law-abiding behavior that Ms. Hicks has conducted herself with for the last 16 years. And that, I believe, is a direct result of her dedication to her own treatment. I would note also she is a lifelong New Jersey resident, has substantial ties to the community. She does not drive. She lives alone in an apartment. She goes to her doctor's appointments once a month. She is on disability, so she does not leave the house to work. And there are very few reasons she really needs to leave the house if that's a condition that Your Honor deems appropriate here. So I do believe that all the factors related to Ms. Hicks and her history and what's going on with her life now favor release. And then turning to the charge itself, Your Honor, of course, must consider the facts of the case and the weight of the evidence and the likelihood that there will be a conviction that would result in incarceration for Ms. Hicks. And I would note that when you look at the video here, when I viewed the surveillance video before looking at the rest of the discovery, I had the first initial impression that Mr. Sanchez presented to the court, because I thought that the woman on the bottom who was getting beat up was the alleged victim. I made that assumption based on the charges. And then when I went and I looked at the discovery and I listened to the statement made by the alleged victim herself, and I read the summary of the statements made by the other individuals, because almost everybody here gave statements to the police, and those were summarized in the investigation reports. And when I saw the officer's observations of severe injuries on Ms. Hicks' co-defendant, and the overall characterization by everyone who observed this event, I realized that this was actually much different than what I initially thought. And so in trying to sort of distill a very complicated situation here, what it seems that everyone agrees upon happened here is that there were two 16-year-old girls who were getting into it online over some issue at school. One of them was the alleged victim, GF, and one of them was Ms. Hicks' 16-year-old daughter, BS. And there was some threat made by the alleged victim to BS. And then Ms. Hicks, not Ms. Hicks, but Ms. Hicks' adult daughter, who is her co-defendant, Miss Amanda Amalung, which I may be pronouncing wrong, took it upon herself to get involved in a high school dispute. And Miss Amalung reached out online to the alleged victim here, GF, and said, I know where you live, we're gonna come over. And this is coming from the alleged victim's own sworn statement. She said, come over, here's my address, and gave it to them, invited them over. And then Miss Amalung, driving the car with her 16-year-old daughter and then their mother, Miss Hicks, unfortunately along for the ride, showed up at this address. GF and her mother come out of the house, and then it is GF, the alleged victim, who initiates the physical confrontation. And this is corroborated, or this is what comes from the statements of Miss Amalung, but it also is what comes from the statement of GF, the alleged victim, who told the police in a sworn statement that she saw Miss Hicks pushing both of her daughters back while GF was coming towards them. And Miss Hicks was physically, this is from the sworn statement from the alleged victim, that Miss Hicks was standing between them trying to push her own daughters back, and that Miss Amalung then came around Miss Hicks. And that's when Miss Amalung and GF got into a fight. And fight is the word that was used by everyone who described this incident, including the alleged victim and her mother. The alleged victim says, we fought. She says, I was fighting the girl with the white shirt, the older sister. She says, the mother was pushing them back as I was going towards them. These are direct quotes I took from her statement. And then we don't see on video this part, of course. I assume the video was provided by the alleged victim or her mother, and we don't know the original form. But what we see on video is that the alleged victim, who's, yes, she's 16 years old, but she's on top of Miss Amalung, beating her, and by Miss Amalung's report to the police, beating her with closed fists and biting her. And that report was corroborated by the officer's own observations on the scene, when the officers said they could see that Miss Amalung, Miss Hicks' co-defendant, face was swollen and bruised. She had cuts all over her face, and she had bite marks on her ear and on her hand, which is exactly the injuries that Miss Amalung described to the police. And what you can see on video is not every single detail of a bite or a punch, but you can see that GF, the alleged victim, is on top of Miss Amalung, while Miss Amalung's younger 16-year-old sister and Miss Hicks, her mother, are trying to get her off. You can see Miss Hicks trying to pull GF off of her older daughter, and you can see the younger daughter kind of kick her to try to get her off. But for, I believe it's well over a minute, which is a very long time to be beaten, the alleged victim is on top beating her, and it is only then that you can see Miss Hicks, and I don't think there's any question here, it's on video, go back to her car and bring back some type of bat and begin hitting the teenager who's on top of and beating and biting her daughter. And when the alleged victim then, and this is what I see on video, either falls off or is pushed off or is knocked off Miss Amelong, it's actually then Miss Amelong gets that object into her hand. Miss Hicks does not continue to hit the alleged victim. Miss Amelong then gets, who has just been beaten, gets the bat, and she's the, or pole, or it's not clear what it is, bat or pole or whatever, gets that, and she is the one who then continues to hit a few times the alleged victim, who is no longer beating her. And then the alleged victim gets up and walks away. Miss Hicks and both of her daughters get into their car. They start to drive away. As the police show up, they stop, they're compliant, they speak with the police. The police speak with the alleged victim and her mother, who throughout this incident has been videotaping and essentially cheering her daughter on in this fight. And Miss Hicks is not arrested on scene. And what the alleged victim and her mother both tell the police is that it was Miss Amelong that was fighting with her daughter, and it was Miss Amelong who hit her daughter with the bat. And while we can see on video that Miss Hicks did bring that bat over, I believe it does make sense that the alleged victim and her mother would reflect on it as Miss Amelong being the aggressor, because she is the only one who hit the alleged victim while the alleged victim was not actively beating up somebody. So all that is to say that there's no question that this incident should never have happened, and that everybody involved bears some fault here. I think I don't contest that at all. It's certainly not contested that there was an injury to a teenage girl that should never have happened. But what is very much at issue here is whether Ms. Hicks' actions, and I disagree with Mr. Sanchez saying I conceded anything about whether she caused an injury by saying there's probable cause. It's exceptionally low standard, and there's accomplice liability and all of that. But I think what is very, very much clear here is that it was Miss Amelong, the adult co-defendant, who was really leading the charge here, was instigating the fight, who drove over there, who got into a fight with a teenage girl, who escalated it after it should have been over. And that Miss Hicks, who should not have been there, was acting in a way, whether it's in a way that we agree with or not, that can be very fairly categorized as defense of others, while her daughter was getting bit, beaten, punched in the face by a person who would not stop despite lesser, more, less severe attempts to stop her. I would note that Miss Amelong, the adult co-defendant of Miss Hicks, her older daughter, who's I believe 35 or 36, and inserted herself into a teenage argument here. Miss Amelong was arrested and was released at CJP on PML2 with no motion by the state to detain her. That was on, I believe, May 1st, she was released. And no charges, and Miss Hicks was not initially charged. Miss Hicks only recently learned that there was a warrant out for her arrest in this case, and she learned that because her neighbors told her, hey, we saw Rahway police at your house. So Miss Hicks called the Rahway Police Department, said, heard you're at my house, what's going on? And when they told her that there was a warrant for her arrest, she brought herself to the Rahway Police Department immediately and turned herself in on that warrant. It is now nearly 2 months from this incident, and there have been no issues, no allegations there's been any contact or threats or any issues whatsoever between Ms. Hicks and any other party involved in this case. And that's important to note in terms of any immediacy of danger to the alleged victim or anybody related to this case. So again, I apologize for being long-winded on the facts, but it's because they're complicated and there's a lot going on here and there's a lot of parties involved. And but what I would ask Your Honor to take away from it is that Ms. Hicks is not the central instigator here, and that the characterization by the state is simply inaccurate and unsupported by the sworn versions of every single person involved in this case, including the alleged victim and her mother and the video. Ms. Hicks is a person who has really turned her life around, is undergoing stable treatment in the community, has a stable place to live, does not live with either of her daughters, and has no reason to go to Rahway or be anywhere near this alleged victim's home. And so what I ask is that Your Honor release Ms. Hicks and require that as part of her pretrial release conditions, she be required to continue with her treatment plan. And if the court wishes her to sign a medical release so that pretrial services can verify that, she's indicated she has no problem doing that. If Your Honor, certainly a stay away order would be appropriate. And if there are any other conditions such as a curfew or Ms. Hicks doesn't drive, so there's no need for a driving restriction, any other limitation on her liberty short of detention is something that Ms. Hicks would have no issue complying with. She knows how important a routine and structure and treatment are to her life, and she would do, as demonstrated by her turning herself in. She's demonstrated that she follows directions of authority, is not trying to evade justice, and will be in compliance with all conditions ordered. And so that is my request for her today.
Thank you. In considering this matter, the court considers a number of factors, beginning with the nature of the charges and the weight of the evidence. The defendant is charged with significant crimes, including aggravated assault, second degree, aggravated assault, third degree, possession of a weapon for an unlawful purpose, and third degree and unlawful possession of a weapon. Those charges weigh in favor of the detention. The facts and the weight of the evidence. I watched the video a number of times. It's a video which is taken from what appears to be the Ring doorbell of the victim's family. And it's odd because by the time the video starts, the fight is already in full swing. But from what I could see, the victim was initially on top of the one of the three women. And let's mute the jail, okay, for now. Thank you. Was on top of the the victim was on top of one of the three ladies, and more specifically the lady in the white shirt. And you can see another person dressed in darker clothes trying to kick the back of that person to get him off that person. Then it appears to me you see Miss Hicks race across the street to the back of a white car, grab something out of a trunk. I saw in the police report it was described as, or in the affidavit of probable cause, it was described as a baton. I don't know if it was a baton or a pipe or a crowbar, but it was something that was a rigid stick approximately 4 feet long and come back, at which point she begins to strike the ultimate victim in the head. Certainly her conduct was far exceeded what you would expect the oldest person in the group to do. But I recognize that it appears from what I can see that Miss Hicks's daughter was on the ground, and attempts to get the victim off the daughter were unsuccessful. From my perspective, there's a whole lot, and I read the police reports and the arguments that precipitated this and the threats and the involvement of social media. And to me, there's a million facts that still need to be further explored to understand how this turned into such a violent situation. But from my perspective, the weight of the evidence is enough to convict, but it's certainly unclear as to whether and Ms. Waters brought it up, defense of others will be a viable defense. But I recognize that it could possibly be a viable defense. So from my perspective, the weight of the evidence slightly weighs in favor of detention. The history and characteristics of the defendant. There's no doubt that the defendant has a poor criminal history, but also she has 10 prior indictable convictions, the last offense being in 1997. She has 7 prior, those are disorderly persons convictions. The prior indictable convictions, it appears that the last was the 3rd degree assault from 2007, for which she was sentenced to New Jersey State Prison. I don't place much that criminal history was not only so long ago for me to place very little weight on it, but in between then and now, there appears to have no run-in between Ms. Hicks and the criminal justice system. So I find that the history and characteristics are somewhat in equipoise. The criminal history combined with the length of time since then, I rely on very little and therefore place little reliance and find it in equipoise. Failures to appear. There were a number of failures to appear, 17 failures to appear, but the last was about 9 years ago. And Ms. Hicks apparently did turn herself in. These charges involve her 2 daughters, and I find it difficult to imagine that she would flee the jurisdiction and leave her 2 daughters alone.
Jersey courts are very serious.
Especially the older daughter who was charged and released to face these charges alone. So I don't find that she is a risk to obstruct. And I find that, as Ms. Waters points out, there was several months in between the time of this incident. It was back on 4/18, so it was about 2 months, almost 2 months transpired in between this incident and the time of the arrest with no contact. So I do believe in no contact with the victim is not only appropriate, but will ensure that the victim remains safe from further attacks. The PSA recommends that the defendant be detained based upon the 3 and the 4 the flag raised. I do not find that the PSA takes into effect the weight of the evidence and the possibility that this was a self-defense of others situation in which Ms. Hicks was attempting to get the victim off the mother. And I do reflect that after that, after the older daughter got off, it appears that was the only time thereafter that the victim was struck. It's unclear to me the injury. She was struck at least 10 times by my counting. Who injured the victim, but from what I could see, probably a combination of the 2 of them. But the point being, it was only the victim was only on the ground after it was only after the victim was on the ground that the daughter struck the victim, not the mother. I'm certainly not justifying what the mother did, but I don't think that criminal justice reform is designed to keep someone like this in jail pending the outcome of the trial. The defendant is going to be released on pretrial monitoring level 3. I'll go through those conditions with her. She's going to be prohibited from having any contact with the victim or anyone from the victim's family. She's going to be prohibited from returning to the city of Rahway. Ms. Waters said during her.
So that is the PSA that they use in New Jersey, public safety assessment. They do it with every trial court case. They use the public safety assessment.
Arguments, and she can correct me if I'm wrong, that Ms. Hicks has no reason to even return to the city of Rahway. And she is going to be required to sign any authorizations requested by pretrial services to.
So she's getting out, people. The rest is just mumbo jumbo. So intense, very intense. It was a Karen fight. I am digging to find it I swear, the day I find it, if I find it, you will be the first to see it. All right, don't know clip of the night. Thank you to Darkova and who else donated memberships? Was it Monkey? Mods, help me out. I know Darkova, somebody else donated 5. Much appreciated. Oh yeah, it was Monkey. And Monkey and Heather, don't know clip of the night. Little Judge Washington. I'm getting to really love Judge Washington's court. You know what? You know why too? Because a lot of other creators don't really cover Washington as much. So I may become the Washington creator because her court is great. So let's go. Let's have some fun with this one, guys. And of course, all right, here we go.
The defendant in this case.
So the star of the show is Miss Nathan. Christy Nathan has been here several times and almost a nemesis of Judge Washington. Here we go.
Was held on trial for assault and battery and was found guilty.
This has nothing to do with that.
It says here that the guilty plea was set aside, yet and still the fact remains the defendant was found guilty of the charge of assault and battery.
I know, Trev. That's why I may be the only one. Because got to get on that Washington train.
All right. So today is not a trial for both of you. It's not a trial. Like I just indicated, ma'am, if there's any discovery that you want to have in this case, it's the day and time that I give you a time frame to have that happen. If there's no
who the account belongs to and where the funds are.
All right, here we go, people. Just give me a second. Gotta find it.
and 15 requests to admit.
All right. So this was between Melissa Floyd and someone who called in.
We'll see you all on August the 3rd at 3:30 p.m.
All right. Miss
Yeah.
Nathan's up
Thank
now.
you.
Here
Thank
we go.
you, Your Honor.
It's going to be
Enjoy, people.
Auto Finance Center of Ypsilanti versus Ashley Carey and Wingate North Royal Oak.
No, here we go. Hold on. All right, there we go. This was a while ago.
BNV Funding LLC versus. All right, we're here on Ms. Nathan's objections to the garnishment in this case. She's indicating that this is a disability check for which you cannot attach.
Correct. So it looks like there was a prior appearance May 4th before the magistrate. At that time, he adjourned it to today to give the defendant some time to, I guess, get some documentation to prove.
So what she's saying is there's a garnishment out of her wages, but you can't do it because it's a disability check. Now we all know you cannot garnish that.
Who the account belongs to and where the funds are coming from, whether or not they're exempt. Our office has not received any documentation. I'm not sure if the court has, but I think that's kind of where we are at this point. And just as a, the bank did garnish $1,007.55, and that was received the day after the hearing. So we did receive those funds.
All right. So, ma'am, apparently the magistrate had indicated to you that you needed to provide documentation of ownership of the actual bank account and where the funds were coming from so that you could have your objection ruled upon. I don't see any documentation in my file regarding that.
So the last judge, he told me a few things to bring, and you'll see the recording. He was going fast. I had to repeat it again. Anyway, a signature letter. He wanted a signature letter to show who is the head on the account. So I did bring the signature letter. Also, okay, and maybe if somebody could teach me how. They told me after the court, whichever way it goes is when they will take the money. And I'm more than confused if they can't take it from one account, but you can take it from this one. Is it because someone else's name on it? So they're basically trying to take it from someone else? I don't, I don't know. It's just not right. Also, this here company, not only do they beg you to get their card, I did get their card, and as you see, I got their card, used it, and paid every month. One time, just one time through them years, I was in a bad position. So I paid half, which is $75 over $169. All next thing I know, the lady next door gave me some mail, and it was a court, something to appear at a court. And then when I got here, I learned who they were. And yes, I did have a card from this place. They turned $169 all the way to $1,007. And both presidents have spoke on this. I don't know the proper word, is some kind of price gouging. I'm not a crook or a scam or none of that. If I owe something, I have no problem with doing that. And they don't even want the money. The last time before I came here, I was told to call them by this office who's in the court and see if you can make some arrangement with them. I did that years ago when this started, and the price kept going and going and going. No matter me paying half, they still put late fees, and it was like no way out of it. I asked them then if they could give me just some kind of complete price without a bunch of extra. They could put fees on it, but this many. So I was not able to handle the extra that they put on. I am able to handle what I owed them. And I don't want, it's not fair. I didn't even know they got the money. Is that legal to take it before we finish here?
So, first of all, ma'am, in terms of the original case that you're referring to, this case was from back in 2020. The action was filed in February of 2020. Looks like she did file no. So was served by alternate service.
They don't want what's owed to them. They want what's owed to them, plus I don't know how much more. They just want to, it's like sucking a person dry. It's just not fair. Nobody know the owner of the account that they would lose.
Mm-hmm. You defaulted by not showing up to court on this case. So that part of the case is already done. You didn't show up when the original judgment, I'm still talking. When the original judgment was entered, you didn't show up. And so a default was entered against you.
My
so
time.
You don't have the ability to go back and argue about the underlying.
No. When I learned I had a court date, I ran in here hysterical and they taught me who the people were, etc. I didn't even know that I had a court or you've been defaulted before in any of this. I'm present and I've been coming since I've learned this. I called them to see who those initials are and what I owe and what's going on. I called them. I don't know about what you said, a default.
Mm-hmm. Judgment by default was entered on October the 16th of 2020, ma'am.
Yeah, I don't know.
You didn't show up until after a garnishment was issued.
I showed up when I got some court papers about with these letter and initials on it. I didn't even know who it was. So in October of whatever year you said, I did not know that somebody this is called suing, ain't it? Suing you? Yeah, I didn't know. No, I know you don't know, but no, I would have come in here then the same way with whatever is needed, especially if it ain't my money and they done took somebody's money. You're not gonna make them pay it back?
I'm sorry, what?
You're not gonna make them pay it back?
Ma'am, you're not understanding the procedure and you should probably seek.
Exactly. That's right. I don't understand. I'm disabled.
I can't give you legal advice. I'm a judge. I'm not a lawyer to give you legal advice. You need to seek counsel.
I still have a chance to seek counsel for whatever has happened. Okay, I don't want to make it hard, but that's okay. I asked people in this office.
Well, they can't give you legal advice either, ma'am. You have to go to an attorney.
fantastic. The showdown.
Is there some, can you make me understand?
I'm sorry, what?
Could you help me to understand something?
I may or may not be able to help you understand, because if it's legal advice, I can't give that.
I was thinking this was like your advice, not no advice. I want to know if they can't bother my disability check. I'm the same name on that one. What is, could you help me understand why it's okay to bother that? And I'm
Does anyone else have no idea what they're arguing about? I watched this like 4 times and I still have no idea what's going on.
First of all, ma'am, I'm trying to explain how you got in this place, because you started talking about the fact that you didn't owe this amount. You only owed $169. That issue never came before the court as to whether or not you had any defenses, because you didn't show up to court after you were served with the documentation. The documentation was served by posting and tacking at the address at 227 South Grove. There is an apartment number, but out of privacy for you, because we're on Zoom and being streamed live, I will not give the actual apartment number so that you can have some privacy there. But you were served you were served by with the summons and complaint by first class mail, and also tacking to the door there. And also they said they served certified mail. So all 3 of those things were supposed to happen in this particular case.
now certified mail, is that one you signed for? Because if not, like I said, I didn't get nothing. I would not have sat there and let somebody sue. I didn't even know I'm
Well, I
suing.
have the documentation here, the receipt that shows that you were served by certified mail. It didn't say receipt return requested. Anybody at that house was going to sign for it. So it did go to that address. It also was tacked to the door at that particular address.
Busted.
You did say someone signed for it, right?
I don't know if anyone signed
No.
for it.
My family, they would have told me you're being
Both
sued.
can't talk at the same time.
Sorry.
So the receipt does not show if anyone signed for it, but they don't have to send that to us. They can keep that in their own file. So I don't know the answer to that. I'm telling you that there were 3 different ways you were served: through the mail, through tacking on your door, and through certified mail. So you can dispute one, but you can't dispute that it was tacked to your door and sent through the mail.
Yes, I can. Well, I don't know if they did that, but I can dispute I did not receive that. I would have been scared, worried like this. I would have come in, not.
She's getting zesty.
So were there 2 different bank accounts that were garnished, Mr. Fay?
We don't. It was just let me just pull up the One Detroit Credit. Sent it to One Detroit Credit Union. I don't know if there were multiple counts with the credit union. We didn't receive the disclosure. We did just receive the funds from the bank account.
Yeah, I do see the One Detroit Credit Union. I don't know what other account you're referring to, ma'am. That's the one that's before this court. The One Detroit.
Okay.
Is there a different one that you're referring to?
I want somebody to show me how they are able to take somebody else's money because my name is on their second.
Does it?
What? What is she talking about?
Doesn't matter how many names are on there, ma'am. If your name is on it, then therefore they can take it.
Okay. And we have no problem with all the price gouging up to $1,007.
I think in a roundabout way, she's asking the judge to help her decrease the money, but she's asking it like a complete jackass.
They took $1,007 and 55 cents.
Mhm.
Mm-hmm.
And I was not at the last hearing, and I know I heard you say that I can go back and look at the video, but that's not how this works. The magistrate, not the judge, I'm the only judge in this particular jurisdiction, ma'am. The magistrate told you that you needed to bring certain documentation here. What was that, please?
This and transactions putting into that account where the 1,755 came from. Putting in it and this, but that's his, whoever trying to sue me, which they already have, right? So.
Yeah, they sued you a long time ago, and they got a judgment against you in 2020.
Mm-hmm. So why was we seeing the man before you, the guy, the other, what did he call it? A magistrate? Why? If I've already been sued and they took the money, why did I
Because
see?
he can take a look at these matters and determine whether or not the money is from disability. And because you weren't able to show that it was from disability, you're before me for a full hearing.
Okay, you didn't tell me to bring some man showing this was disability. They said that on the last,
On the last,
this was wanting you to make sure this is all legal, you know, that they could take funds from the account, because my name on their secondary.
You wrote on here that the funds that were taken, the writ was not properly issued as otherwise invalid because of disability. That's what you wrote on your objection, ma'am.
The rent was what?
The writ was not properly issued or is otherwise invalid because of disability. That's what you wrote on your objection.
She's great.
Okay, so they are able to take this people disability checks.
No, that's why we're here, because you need to show that it's from your disability check.
No, that is not what he said. I can't wait till you look later. No.
No, that's why we're here. No, it's not.
I want to even mention that.
There will be a looking later, ma'am. That's not
him. This is, he know that. He said that.
Who, the presidents?
Mr. Fay, is there anything else you want to say about this?
No, Your
She's
Honor.
saying it's not based on disability. Is that what the magistrate was saying?
It is a disability and they took the money. I just wanted somebody to make sure that this is legal, that they take.
Ma'am, are you arguing that this is your disability or not? You keep, every time I bring it up, you go to something else.
I am. So yeah, my funds are coming from disability. I still don't mind paying whatever is owed or so for this 1,000, because it's just went way over. This is horrific, 1,007. That's
Ma'am,
all.
the judgment against you is for more than that.
My last visit, we was at 107. Before I left, this screen I'm talking to, it was, he done added like $200 on there in 3 days.
Since I last looked at this screen I'm talking to.
That's not right. He added 300, I mean, 2 something.
What are you talking about?
It was 107, whatever you said, 55.
The judgment in this case was for $1,199.04. That judgment was entered back on October the 16th of 2020, ma'am, in that amount.
Okay, I'm getting papers that say 107. I'm thinking 55.
That's what they took.
Amazing. Absolutely amazing.
Well, you know, Mr. Fay, why do you,
all I care about is
one second, ma'am. I was just talking. Mr. Fay, why do your numbers say something different? So the judgment originally was for $1,167.12, and now you're saying the balance is $1,199.04. Is that correct?
No, so that would have been the balance before the garnish or the funds were applied. So as of today, the balance is $193.92.
I guess what she's trying to ask you right now in a roundabout way is whether or not you're willing to just settle for the amount that you took so she can stop fighting over the $1,755.
It's a possibility. I can't approve that right now, but I can see if they'll take the 1,007 as to satisfy the account.
Is that what you're asking, Ms. Nathan?
Yes, if this price is legal, why didn't it stay at the paper at the 1,007? And that's what I'm saying.
Undercover, fantastic clip. I've been saving this one. Oh God, if it's legal, if it's legal, I can't.
Ma'am, did you actually hear the words that come out of my mouth?
I'm sorry.
At the 1,007, and that's what I'm saying.
Ma'am, did you actually hear the words that come out of my mouth? I just told you that the judgment in this case back in 2020 was for $1,167.12. That's the judgment that was entered. Do you understand that part?
Yeah, now I do.
Okay. What they told you the $1,007.55 was that what they took from your account.
What's up, Daylight?
That's what they took
now
to satisfy that full amount. Okay, do you understand that part?
Yeah, yes.
So once they apply the 1,007, you still have a balance that is left.
Mm-hmm. I hear you.
Okay. So earlier, you just said to me that if they were to be taking the 1,007.55, you'd be fine with that. Is that you saying if they will settle for that amount and not come after any more, you're okay with that? Or you still want to fight for your $1,007 and show somehow that that is disability?
If I'm not happy with the 7 because that is disability, but if this is the way y'all want to go and it's going, because my nerves are my health, I can't take it no more.
What?
If he could stop here at 1 whatever, and I don't want the name suing on my name.
But ma'am, you already have a judgment against you.
Which is a suing?
Yes, ma'am, that's what it is. That's when you get sued and you lose.
We now have a new term here on Time Served. Suing. We now have a suing. Okay, so this is a suing case.
It's called a judgment.
No, it's a
That's
suing.
what that is.
Suing.
It goes on your credit report. It's been there since 2020.
Okay, I didn't know that. Okay.
Well, now you know.
So can we stop here with this extra money fees? Because I told you it started at 169 and went to 1,007 through the time. And it is unfair. Both presidents talked about that gouging.
What presidents? Is she talking about Trump and Biden? Like, who is she talking? What presidents?
So yes, can it stop here at 107 or whatever you said?
That's her argument?
I think you must be talking to Mr. Fay.
Yeah.
I don't get to make that decision, ma'am. He has a judgment. That's not how this works. That's why I've been trying to tell you, you should seek legal advice.
Oh. Okay. Okay.
So just looking at it, since we received the 1,750, or the amount that we received, I can go back just to verify. I don't think it will be an issue, but I just need to verify first whether or not I can satisfy it.
Can you use other words other than that so she fully understands what you're saying?
Sure. So I don't think it would be an issue to close out the account. I just need to verify with our client, just to confirm with them that they would be willing to accept the bank garnishment amount of $1,007.55. And if they do, then we can go ahead and file the documentation to close the account with the court to satisfy it.
Do you understand that part, Ms. Nathan?
Yes, I did.
And just so you know, this is not legal advice, but it doesn't mean that the judgment goes away from your record.
She crying?
So I can still seek legal advice after this, right?
What?
You
Is that-
can. You can certainly do that now. Yes. What I'm going to do is give you another date where you can come back. Are you still listening?
Yes, I am.
Why are you crying?
I can give you another date where you can come back and he can tell us whether he's gonna accept that amount. And then you can talk to an attorney about what your rights are with respect to the garnishment. Okay?
Yes, I understand.
Judge, take a deep breath, Judge. Relax. Relax. Do you understand the words coming out of my mouth? Yes, she said that. Thank you, Monkey. Thank you, Heather. It just
So, ma'am, are you saying that the funds in this account are yours or all someone else's?
This is what happens.
What?
I was grateful that they allowed me to put my name on it when the corona stuff came. So if I need some help,
the corona stuff came. Guys, the corona stuff came. Yes.
I was grateful that they allowed me to put my name on it when the corona stuff came. So if I need some help, I could have help. So sometimes you'll notice I'll go and take money out and I hurry up and put it in so they won't know, that I'm, use that amount or whatever. So yes, you'll see my name putting in there after I done took it out though. You'll see whatever I took out, I put back because it's not mine. Yes, I appreciate having help, where I can go in or out. And when I need
What does this have to do with anything?
help, that's what I do. But I make sure now I'm in trouble for putting it back in. But I put it back in so it would stay the same balance for 'em. So yes, that's my money I'm using to put back in there. And that's where it's come from, disability check. I'm not asking for nothing special, I swear. And I believe when people use something or borrow something, they should give it back, which is what I'm in this for. So if I owed them money, I had called then, now, and nobody wanted to settle. And, until today, thank you for the 107. But I'm still very unhappy with that because I don't see where I cheated or went wrong. And, like if he had a paper that say I owe 169 and he wanted to put another 400, 300 on it, I would still do that. But to take a hard earn, most know how hard it is to come up with $1,000. And I just thank God I was able to put it back in there.
But when they originally filed this case, ma'am, they claimed that you owed $941.
I know that's the part I hate. I wish I could have seen it, had it, been going through everything these last few years with my parents and their illness, and now that I have. So yeah, I didn't get it. I wouldn't lie. I would pay. I'm not anyone to know me. I would be embarrassed for them to know I'm in some situation like this because I help others, let alone leave my own balance. I just didn't want you to price gouge. That's all.
Right.
And I appreciate you taking the time, and him too, to explain to me this.
I don't know if legal services handles these type of matters, but legal services has office hours between. Do you have a pen to write
Legal services has no idea what they have to help her with.
it down?
Well, the retired judge, I still got the number to the class that he taught, and I thank God for him as well.
What?
And so I will use that part of the legal aid, the one that he trained. I can't think his name. I'm a little messed up right now, but
Judge Pope?
Yeah, oh God, yes. Yep, can't run no racist stuff on him. He is a normal man and he do not see color and he try to do what's right by people. He did. Yes, he did. And I'm grateful for him. I got a legal aid number, Your Honor, and I will use it. And they helped us then and they'll help today.
Okay.
And they can understand everything, you know. I appreciate you. I know the position. You cannot tell us.
So I'm gonna adjourn this to.
Wait, let me write that down. I ain't got no memory. That's why I was trying. That's why I didn't understand a lot of stuff earlier. All right.
What you gonna write down the new date? Is that what you're writing
I
down?
want to. Yes, ma'am. Yes, Your Honor.
July 13th
Oh,
at 2:30.
We will be here.
You can't just call them over at Legal Services anymore, ma'am.
Oh.
You have to go in. That's why I'm gonna give you the office hours. Okay?
Okay.
10 to 11:30 on Tuesdays and 2 to 3:30
She's in the courthouse.
on Thursdays.
Got it, and I appreciate it. And I appreciate you, sir, on the other party, even trying to take away a few hundred. Anything will help today.
All right. July 13th, 2023.
Yeah.
2:30 p.m., ma'am. Go over and see legal aid between now and then so they can explain everything to you so you can get a better grasp on what your rights are and what you can and cannot do. Okay?
Yes, Your Honor. Thank you.
You're welcome.
That clip was a show. Wow. Wow. All right, guys. That clip was sponsored by those friendly donos. Thank you so much for everything. Kitch is always up live. Cooking them something good. I think she has that, what's that, Dan guy? I like that. Kitch is great. All right. Go check her out. I will be live tomorrow. I have a Simpson premiere tomorrow. Thank you, Flying Monkey. Thank you so much. I want to go to legal services because of that Corona hit. Guys, thank you for everything. God bless. Stay healthy. Kiss your loved ones. Don't go to bed angry. I'm Phil, and you have been served. Good night.